Hi there, and thank you for tuning into You and Your Money. I'm your host, Bryan, and tonight's program we are focusing on estate planning, offering insights and guidance to help you make informed decisions. With people living that much longer, estate planning becomes more vital. One of the concerns is how do children help parents who become unable to deal with their own affairs. There's a belief that a power of attorney is the solution. And joining me this evening are Harry Joffe, Head of Legal Service Discovery Life, and Gordon Stewart, Managing Director of Acura. Gordon,
yeah,
good to have you in the studio.
Yeah, it's good to be back.
Coming back from Mauritius, you can't. In Mauritius, you can't stand up. I think you wear short pants.
Well, yeah, Bryan, I'm actually wearing long pants for I think the first show in years.
Yeah. Gordon, you've lost weight. Well done.
I have, thank you. It's trying to live a healthier diet, and obviously the older we get, the more we have to look after
And you guys reminded me that you've been on my program. We've been doing this program for 15 years.
15 years.
Well, I know I've been doing it for 20 years. It's quite amazing.
When I first came on, Man United had won their last trophies. That's 15 years ago.
Okay. Harry, so let's talk about the two levels of individuals. You've got the affluent and you've got those with a lot less income. So now, in South Africa, we don't have an enduring power of attorney. Correct. So I understand it stops when the person who's given that power of attorney is no longer capable of handling their affairs.
Right.
However, institutions don't seem to take much notice. So what does one do? We talk about affluent, which is going to cost more money to do things, and those who are less affluent. I mean, someone with a mother who just gets a pension and a little bit. How would you suggest one deals with this?
So, Bryan, let's just go back a step and just read the law into the process. So, we don't have an Act of Parliament, unlike the UK and other Commonwealth jurisdictions. So we're working on our common law. So in terms of South African common law, it's law of agency, which means if a person who gave the power of attorney is no longer capable of appreciating it or able to withdraw it, then that becomes null and void. So the minute you lose your mental capacity, that power of attorney is null and void. Now that means you've got to look at other options. So the first point is your institutions are changing. I know at Discovery, for example, when we get a power of attorney, every year now we ask for it to be redone because we want to make sure the person who's doing it can still sign it and is able to appreciate
Harry,
it.
just a question there. Is that now, do you think that's a requirement or is it just Discovery's requirements?
It's just our requirement at the moment, but I tell you it's catching on amongst the industry. Everyone is now becoming more aware of this issue because it's such a common problem. Now, you said, what do people do? So if you've got a very small estate, and typically under R1 million, then you can actually go to the master and you get an administration letter. And that's a much simpler process, assuming the master, of course, is open and working. You get this letter from the master, which allows you to administer it temporarily on behalf of the individual. So you don't need to then go to court.
Okay, you use the word temporarily. Explain that.
So the master gives you this letter, and we've had it a couple of times for smaller clients who needed to pay for example, old-aged homes and small things. And then they give you the son the letter to administer that estate for the parents. But the minute it's more than R1 million, the master won't do it. Then you have to go to court and get a curatorship. And that's a complicated process. And of course, it costs money and you need a counsel involved. And it's not straightforward.
You need doctors involved as well.
Correct. Well, there's been court cases as well, which is interesting, where the individual who was supposedly incapable came to court and said, there's nothing wrong with me, I'm fine. And on that day, he was lucid and the judge didn't give the order. And then you've got a cost order against you and you haven't even got the curatorship. So it's a problem in our law, and it's a big gap. I can tell you, I think it's 1999, Gordon.
They've been working on it for a long, long time.
The Law Society has made this proposal to the Law Commission to change our law to make it more like the UK with an enduring power of attorney that hasn't become law. And we sit now with this gap. And of course the answer, and I'm going to lead into Gordon after this, the answer is, of course, if you know you've got an issue coming, you know your parent in the 80s and you're worried, start moving stuff into a trust. Gordon, I'll hand over to you about a trust.
Yeah, no,
Harry, so but you mentioned the amount of R1 million. R1 million, is that in total of assets?
Yeah,
I mean someone's got a home worth 2.5 million. So they're asset rich but income poor. They've got a pension coming in and they've got savings of 1.3 million. They've got and the cost of a curator is enormous.
Yep. The Act is actually less than R1 million, I must tell you. I can't even remember what the amount is in the Act, but I know up to about R1 million, the master will still give you that letter.
So Gordon, talk to us about, now we're talking about moving assets into a trust. I mean, we're going to talk of, there is a question about the bottom drawer trust. We'll come back to that in a moment. But the mechanics.
So-
Setting up a trust, 1.3, 1.5 million, I mean,
Yeah, you see, Brian, this is where you're kind of caught between a rock and a hard place, because as Harry's pointed out, there are only a couple of options that you can do when the individual gets to the point where they lose their mental capacity. And we've already said now that the power of attorney is not going to work. So either it's administrator, or it's a curator, or it's a trust. Neither of these are fantastic options, which is why we were talking now about getting this power of attorney pushed through Parliament, which becomes then a more enduring power of attorney. But yeah, I've mentioned it last time when we had the talk with Davis, and I've been through this experience personally. My dad had Alzheimer's. But fortunately, he had done his planning long enough in advance that when he did get to the ability where he could no longer look after himself, the trustees were there to look after him. But Brian, there is no other real happy, magical solution other than trust, administrator, curator.
And Bryan, to be honest, what you can do, I mean, I know of a couple of trusts of, say, 1.3 million rand worth of assets. What you do, you speak to the accountant who's managing the trust or the main trustee. You say to him, we can't afford major fees, we can afford X amount per year, and you have to just do an agreement on the fees.
But you know where this is going to get slightly more complicated now is now that South Africa is on the grey list and you've got these FATF requirements, and you've got all of these kind of omnibus laws that are coming through, it's getting harder and harder for your average run-of-the-mill trustee, professional trustee, to keep pace. So when you start relying on maybe a more softer or friendly accountant or attorney who's doing you a favor, I think there's going to be a lot less of those people who are willing to take up that role.
They won't do it for free.
It's just so much admin now.
okay, so I want to put, I mean, it's a big subject, but I want to put a cap on it. We've probably got a lot of viewers listening tonight who may have power of attorneys on their family, mothers, whatever the case may be. Practically, what do they do?
So as Gordon said, Bryan, I mean, you've got to, if Mom has lost her capacity now, the power of attorney is not valid, a trust is cheaper than a curatorship, I would say. Although not by much, but at least.
But who wants to form a trust? Gordon, you run big trusts.
Yeah.
You run smaller trusts. But you've told me this individual it's not worth him having a trust.
Not from a costing perspective and maybe a strategic tax planning perspective, but this is now bringing it right the way forward, almost just to deal with your day-to-day administration. So therefore, it's not like your individual who's wanting to plan for their estate for future generations. This is something that you're putting in place to help you cope with a particular problem.
Let me give you a case, Bryan, we had, and it's a very sad case, but it will happen to our viewers as well. So we had an individual in an old age home. She had no money apart from a unit trust investment with us, which was about R1 million, which was enough to keep her going. So now her power of attorney is no longer valid because she's lost her mental capacity. And her son had been honest with us and told us that. Now the son has to pay the old age home fees, which are about 25,000 rand for the month, which he couldn't afford. So he wants to sell units in the unit trust to pay his mom's old age home fees. We couldn't do it for him because we know he's got no capacity to act on behalf of the mom. He had to go to the master, get an order. By that time, the fees had been overdue and the old age home was going to expel his mother.
I think also one last thing on this topic is that there may be a temptation to pretend that mom and dad are okay.
Yeah.
No, that's very risky, because if it comes out that you were acting on behalf of that individual when they did not have the capacity to,
Correct.
you are no longer acting as the agent. So you can then be held liable.
Well, I've got an email on that one, so you've virtually answered
And if
that.
the other heirs that think that their inheritance
That's
has been
exactly the
depleted,
email I've got.
Yeah.
But Gordon, let's just talk about foreign trustees, because again, a lot of parents have made, even trusts now, have made children living all over the world trustees. And let's say one kid's living overseas and two are living here and they're the trustees. Can you have a foreign trustee?
So the law is yes, you can. If I look at Mauritius, you can have up to 4 trustees. You do need a trustee in Mauritius who's with the Financial Services Commission, but that doesn't stop you from bringing in, say, a Bryan to act as. But then what you've got to do, Bryan, is you've got to go back and actually have a look at is this going to create a potential place of effective management and / tax issue where that specific trustee is sitting? And second of all, from an administrative perspective, it's very complicated because you need often wet ink signatures. So if I need a resolution to deal with a bank, for example, I get the resolution, I email it to you, Bryan, but you've now got to print it out and sign it wet ink and then DHL it back to us. And at last cost, I think Yasmin was telling me that it's about 1,300 Rand for a DHL envelope to be sent from South Africa to Mauritius. So practically speaking, it can be done, but in real life, it doesn't happen.
And Bryan, I must tell you, the master, if they find out that the trustees living abroad are not happy. So, I mean, you won't get a letter of authority when you start. If you register a trust, if the trustees are abroad, they want the trustees to be in South Africa.
Yeah, and look, never ever try and have a an offshore trust here in South Africa. That just defeats the whole purpose.
Okay, so let's now talk about, we've talked about going to the master's office, but a couple of the master's offices have been suspended. What does that mean? And they talk about, for once, they talk about the masters, because everyone perceives one master, one person sitting at the top with all juniors. But there are masters, and we've had suspension in Pretoria, Johannesburg, and Bloemfontein. Now, how does that affect how does that firstly affect letters of executorship? And the second thing is, even more important, we talk about a trust and having to, one trustee's died or one trustee's resigned, and now you have to replace that trustee, and you can't make decisions without replacing that trustees, and these masters offices.
So let me tell you a case we had last week, and maybe my viewers and Gordon can give me an answer. So we got a trust with 4 trustees, owns a life policy with us. Now the one trustee has resigned. They can't get a new letter of authority from the master with only 3 trustees, so the letter of authority still says 4 trustees. That 4 trustees resigned and gone off. They want to now change the policy. And it's a serious issue because the individual's not so well, but they can't get the 4th trustee to sign, and we're not going to allow them to sign on 3 because we don't have the right letter of authority.
What's the minimum number of trustees in the deed itself?
Well, 3, but all 4 still have to sign something to let the 3 to act. Because we got.
No, you're right. Because there was that court case a while back where it was held that even if you resign as a trustee until your name has been removed from the letter of authority, you still remain as a trustee for that period.
And Bryan, let me tell you something else. One of the master's offices has actually shut because they didn't pay their electricity bill. So that's the whole master's office in itself is actually closed for the moment.
Well,
but the other master's offices, to be fair, although the master himself or herself might have been suspended, the offices are still theoretically running because they've got juniors.
You can't, if someone dies or needs a change in Johannesburg, can't go to another master's office.
No,
it has to be done.
No, it's where the assets are held.
So you can still go to that master's office and hopefully someone else in the office will help you, but it hasn't, put it this way, it hasn't made the service any better.
Okay. Well,
But if you've got 4 trustees and the majority is 3, then as long as the 4th trustee is aware of the decision, they don't necessarily have to agree to it.
But he's got to be part of the process. Now, this chap has resigned and gone off, and he's not part of any process.
Is he? Can you not get hold of him to inform
Not
him?
involved in that trust at all.
I love Gordon and Harry because whenever I try to go for a break, very difficult to get the two of them to stop talking, but we'll be back shortly.